what is a distinctive trademark, and why should I care about whether my trademark is distinctive? Trademarks are sometimes called source identifiers, which is a weird way of saying it, but what it really means is that they identify who makes the product or who offers the service. So a shoe with, let's take for example, the word Adidas on it. You can see Adidas back here too. A shoe with this on it, or that well-known symbol that you see for Adidas, lets people know that this shoe comes from Adidas, a particular source, or at least from someone who's authorized to make Adidas merchandise. Now, to serve the purpose of a trademark, that means the trademark has to be distinctive enough that a consumer who sees it would think, oh, that's a brand that belongs to one company, as opposed to a merely descriptive term or a generic term. Because if this shoe just simply said soccer shoe on it, then it could come from anywhere, and consumers may not necessarily associate that with one particular company. So context also matters here, because some terms that may be generic or merely descriptive in one context could actually be somewhat arbitrary in another context. Take, for example, Apple or BlackBerry. Before computers were called Apple and before mobile phones had been called Blackberries, if anyone still used them, at that time they were fruit. And so it would be generic to use BlackBerry or Apple to refer to fruit that you were selling. But if you're selling a computer or a mobile phone, those terms are arbitrary, as we call them, which means they're distinctive and they can function as trademarks. Courts sometimes think about these things on a spectrum. On the one side, you have terms that are generic, and generic terms really can't ever function as trademarks. They would be like soccer shoe. On the other end, you have arbitrary terms, like I mentioned, for Apple for computers or BlackBerry for mobile phones. You also have what are sometimes called fanciful or coined phrases, made-up phrases like Xerox or Kodak. In the middle of that spectrum, you have suggestive marks and you have descriptive marks. A suggestive mark is something, like it sounds, it suggests or calls to mind certain features of a product or service, even if the term doesn't explicitly tell you what it is. Think like Netflix as a good example. Netflix suggests there's something about movies and something about online or the computer. It's a suggestive mark, and it's considered distinctive from the outset and can function as a trademark. A descriptive term, however, it just merely describes what the product is or does or features of the product. A common example you sometimes see is cold and creamy. That phrase, cold and creamy, for ice cream really wouldn't function as a trademark because many businesses in the ice cream business might recall their products cold and creamy or refer to them as cold and creamy. That said, over time, a descriptive term can acquire distinctiveness. Think about terms and trademarks like American Airlines or Bank of America. Now, at first, those would be pretty descriptive terms, a bank in America, an airline that's American. But over time, due to long-time use and exposure, those terms have acquired distinctiveness, and now consumers understand they identify a particular business. Now, obviously, the line between a suggestive and a descriptive trademark can be blurry. And some marketers kind of like descriptive terms precisely because they tell the customer what the product and service is without the need for extra advertising. And sometimes there's a need to get domain names or keyword advertising where marketers like to use those kind of descriptive terms because they know that's what customers are going to be typing into the search engines. But for the same reasons, descriptive terms are often harder to protect because so many people use them. In fact, sometimes with taglines or catchphrases, people want to claim these as trademarks, but they run into these questions and issues of descriptiveness. Sometimes a tagline or a catchphrase is just too descriptive and not trademarky enough to identify a source. This is a common misunderstanding, and just because you file an application for a word or a phrase that someone else may not have filed yet doesn't mean it can actually function as a trademark. Now, there are still often some very good reasons to file a trademark application, even if the term you want to file is close to that descriptive or generic line. One particular reason is defensive. Because if you could get a term registered or that phrase registered as a trademark and maintain the registration, it can be a helpful defense if someone later claims that you're not allowed to use that term. And sometimes, since it's debatable whether a term is sufficiently distinctive because it's suggestive or arbitrary or fanciful, or whether it's merely descriptive or generic, because that issue can be debatable, it may be just as well to file something and see how it turns out. But all this is to say that it's important to understand that if the term you want to register, even if it seems available or not taken by somebody else, still needs to be distinctive enough to serve the purpose of a trademark, which is to identify the source of the goods and services that bear that trademark. If you like this kind of thing, trademark and franchise law, copyrights, patents, and other legal stuff, or maybe if you don't like those kind of things, but you just like trivia and you like to see regular pictures of our canine law clerk, you can like and subscribe, and you can also sign up for our newsletter in the link in the description. We hope you enjoy.